So, welcome to today's webinar. Let's jump in. So, just kind of setting the stage, if you will, for the first 20 minutes or so, we're going to do a little bit of a look back on the previous 6 months, beginning of this year. And then we're going to kind of do a snapshot from this point and look to the end of this year. So, kind of a look forward, if you will. And then lastly, we're going to talk in general a little bit about what should be our priorities? What are the general sentiments? What are kind of those trends and so forth that we're all beginning to see kind of develop as we move forward in a very, very, very busy space indeed. So with that, let's get into the 2024 first half look back. So Vale,
Yeah,
you
happy
want
to
to
start.
get us started a little bit?
Sure. So a couple of interesting points before we jump into actually what happened in January. And by the way, Future Privacy Forum has a great report on some of the enforcement trends as well that covers these. So quick plug for them. So GoodRx, Premom, and BetterHelp were three FTC actions from last year, actually. But they started or they continued a theme that you'll hear throughout here, which is and Federica and Kate and Paul would love to hear your opinions, but it's sort of this revisiting of legacy ad tech practices and viewing them from a completely different light, ultimately. BetterHelp is a really great example. BetterHelp is a health-related website, and the FTC basically ruled that the sheer act of people entering their email address and BetterHelp collecting that and using that for additional purposes meant that they were using it in a manner which might violate the health breach notification rule, which is interesting because otherwise I think that was viewed as somewhat of an immaterial collection. Somewhat similar in GoodRx and Premom, they were collecting data for basically for ad tracking purposes and ad purposes, and they were viewed as triggering the health breach notification rule under the FTC guidelines. So that kind of brings us to something that did happen this year, which is the Kachava case with the FTC. Really similarly, Kachava is depending on who you ask, you could either describe them as a mobile attribution and analytics company or a data broker. Again, it depends on who you ask and who's writing the article. But similarly, they were collecting information such as precise geolocation data for mobile devices to help their providers with advertising. But the FTC didn't agree with that viewpoint, basically. They argued that such practices violated Section 5 unfair practices and that they were unauthorized sale of location data. So that is a theme that we've seen throughout. I'd love to hear from Federica, Kate, and Paul what else you've seen on the enforcement side. But I think that health data and the revisiting of how information is perceived, we've seen some similar things with tax providers earlier as well. What have you seen?
Federica?
Sure. Well, I start actually with a recent one, which is on a sort of like a different topic, but it's kind of kids' data we got after Sephora and DoorDash, which were more kind of on the advertising attack side of it, on the sale and sharing of data. The latest and third enforcement action under CCPA and COPPA actually is on minors on Tilting Point Media, and it's kind of a game maker that was collecting and sharing kids' data without parental consent as required under COPPA, but also without the consumer consent for users between 13 and 16 years of age. So this is actually the first CCPA enforcement actions involving minors. But it's also, like, I think, a good reminder for everyone that while we always think about CCPA as kind of an opt-out regime, when it comes to kids' data, it's kind of an opt-in regime for the sale and sharing of this type of information. And I think it's, everyone is focused on this. We are going to see these more and more. And what is also interesting in that enforcement action is the fact that it observed that the app was incorrectly configuring SDKs, software development kits, for collecting the data and unlawfully sharing the data. And so what was called out is kind of, apps should really think about an SDK governance framework, like, understand with your teams how, these apps are collecting data and sharing this information. And obviously, to your point, Val, we have seen also beginning of this year, X mode and in market FTC enforcement actions really focusing on location data as sensitive information and subject to like opt-in requirements effectively when it comes to respecting and honoring consumer choices in the sharing of the information with advertisers.
And the only thing I'm going to add, so I think what we're seeing is sort of focus on the sensitive data categories. And I think two of the themes that we really want to highlight as we talk through the entire presentation today is sort of taking a risk-based approach to your compliance, as well as really being technically educated. Federica was talking a lot about SDKs and sort of how those are configured and what we're what we're seeing as far as enforcement in relation to the SDK specifically. And it's really, really important to understand the technical components of SDKs and how they work, and as well as sort of the risk-based analysis. Fortunately, for me at Snyk, we don't manage a whole bunch of sensitive information, so a lot of this doesn't necessarily touch the way that I advise my clients every day. But it is important to think about how, these different types of data and how you're building your compliance program on a sliding scale, depending on what industry you're in and the types of data that you're collecting.
That's actually a great point, Kate. And I think I'd love to talk more about it. I think sort of to that end is DoorDash, right? Like DoorDash isn't about sensitive data. I think that was sort of the point that was remarkable about it. It was that basically DoorDash was doing something that, and by the way, it violated according to the California AG at least, it violated the CCPA and the California Online Privacy Protection Act, which is CALOPA. I don't know if that's the right way to pronounce it. But to that point though, right, Kate, like many tech companies, SaaS companies, etc., engage in marketing co-ops, engage in using platforms, marketing analytics companies, right? The Kochava case is an interesting cautionary tale in that regard. But DoorDash is not a healthcare company, right? Many of us have used them, right? But for those of you who aren't familiar, they're a food delivery company that's super popular in the US. When Val's espresso machine is out of beans, that never happens. But if it did, hypothetically, he might order from Tate, in the Boston area, and they might deliver me a cappuccino, right? That might be through DoorDash as an example. That's a fake example. That's never happened. But the point is that basically them participating in a marketing co-op, which I think, Kate, to your point a little bit, is a little more universal and requires a technical understanding. What is a marketing co-op? What are marketing teams doing, and what does it actually mean, right? Mm-hmm. And in the DoorDash example, basically they contributed personal information in exchange for the opportunity to advertise their products to each other's customers. That's what the co-op is. It's sort of an exchange. And under CCPA, that is considered a sale, right? And so not only do you need to be super in the weeds on some of this stuff, and I don't mean legally in the weeds, I mean understanding what marketing is doing, how they're interacting, what the paperwork says, because now these cases are coming down where a lot like the healthcare stuff, information that was seen, and that sort of was my point earlier with this BetterHelp case, right? This seemingly benign information that's been used for years or decades by people not thinking much of it now needs to be revisited, which requires that practical approach that Kate was talking about.
One additional point I will make is that in addition to understanding technology, understanding your supply chain, one issue with DoorDash was also that they were unable to determine which vendors, which downstream companies had received the data. It couldn't reach out to those companies to ask for deletion or stop processing data, which was really tricky because it means like you're not having audit, rights over your vendors. And it's really, of course, a challenge with, the sale and sharing provisions.
I think it's a lot like, I know this is an old wound for some of the people on the call here or those listening in, but it reminds me a little bit of Sephora, which is that I think that my impression of what I saw prior to Sephora was similar, which was tons of companies were engaging in tracking, but they weren't necessarily chasing down DPAs or service provider agreements with their analytics providers for ad tracking, in the same way that they might be for, say, their cloud hosting provider, right? And I think that's exactly what we're kind of seeing here, Federica, to your point, which is that, yeah, sure, they are a vendor. They might be in some vendor list, but they weren't necessarily seen as sub-processors. They weren't necessarily seen as doing something that was on the radar of people taking a risk-based approach previously, right? I think many folks, right, and we don't need to admit it on the phone here, but like many of us, right, were, in GDPR days, right, as we were preparing, we were looking at the biggest, most material contributors to the processing, right? That was probably your cloud hosting provider or your CRM or your email provider. Fast forward to CCPA, a lot of people kind of rinsed and repeated. And what happened post Sephora was that you saw a massive surge of people having do not sell disclosures, disclosing that they do sell, having cookie banners pop up, having my privacy choices splitters pop up. And that really does require you to take this practical approach, because while these things are fascinating and they come quickly, the reality is that like you should have already been paying attention to your vendors. You should have already been maintaining those relationships with your marketing teams and knowing what they were up to, so that you could kind of, you know, have an early detection system versus I just saw it on TechCrunch. Oh no.
Right. You know, if I could jump in, a couple of things that, you know, kind of stood out to me in the first half is a revisit, if you will, of some of the basic principles that we've all have grown to know for years and years, particularly in some of the first actions by California, which is all around you know, minimizing the data you're collecting. So, you know, previous conversation, right? We need to all be on the same wavelength, if you will, or all aligned in going in and talking about marketing and advertising, understanding all those flows in and out. The California stepped in and said, you know, some of this data you're collecting, while certainly can be collected, there's not set up for the intent that you are describing, right? It's not necessary. For if I am, for an example, if we're setting up for an email newsletter, you really don't need much. Maybe first name, maybe to personalize it, email address. Other than that, there's not much you need other than those two bits of information. So the idea that we're asking for all this other stuff is violating that basic principle under whether OECD or GAP principles, right, of collecting only what we need and keeping it to a minimum. And I think that's an important thing. That's certainly something, and having worked in the marketing area, the previous employer, that's a wake-up call that marketing needs to hear loud and clear. You cannot, just because you want it and you may use it at a future date, does not give you the ability to collect it today, because the intent isn't there. So
that's a great point, Paul. Let's
Yeah.
jump to
Yeah,
items
number-
here.
So
Awesome.
let's talk about the third-party trackers and wiretapping, because that's a fascinating scenario that's kind of creeped in over the last 6 months.
So I think we have a lot of views on it. Kate, I'm going to put you on the spot for a minute, because I think one of the first folks who taught me about, so while we've been seeing a lot of information about SIPA, Electronic Communications Act, the VPPA, et cetera, recently, this actually started happening a number of years ago with session replay. And the person who actually started to explain that to me was Kate. So Kate, could you explain kind of where you started to see some of the wiretap action a few years back with session replay?
Yeah, absolutely. So, session replay is a really, really interesting technology. What it does is it's very similar to an analytics technology. And what it's going to do is it operates sort of as an event listener. So as somebody navigates through a website, the session replay technology is going to capture things like button clicks, hovers, focus, the activities that a user is doing on a website to interact with that website. It's sort of point in time. And then what the session replay provider does on the back end is it reconstructs those events so that it mimics a recording, but it's not actually, from a technological perspective, a recording. It's more of a reconstruction of sort of event snapshots. It's almost like a flip book or something like that, if you remember those from when we were kids, maybe. But what's happening is we're seeing these wiretap laws be used to say, hey, the event listener is actually interceding and interrupting the user, my communication with this website. And what's really interesting about it is that these are really old laws that weren't sort of intended for this purpose, and they're being repurposed and applied to the new technology in sort of a way that it's sort of a little bit of apples and oranges, which is why some of the earlier actions were dismissed. And the courts sort of said this doesn't really apply. But what we're seeing now is we're seeing attempts at additional jurisdictions and additional legal frameworks being used to sort of target these different sorts of technologies that sort of smell a little uncomfortable when you're thinking about a privacy from a privacy lens.
So a lot of these laws, I know there's a weird parallel between folks who've done telecom and privacy. I thought I was the only one at some point years ago, but there's quite a few people who end up doing both. And telecom laws have rules around one party and two party consent, right? Some of those are like Nixon era, the feds listening on the phone type cases, right? And that's what they were about. And what ended up happening is that at first with session replay, which is what Kate was mentioning, people were seeing the fact that it was a, high fidelity compared to cookies and trackers, version of the ability to see somebody's, behaviors. And they're like, that sounds like a wiretap, right? And they started to put these same rules around, okay, have both parties consented in a two-party consent state?
Right.
In a one-party consent state, has there been notification, et cetera? And they kind of took laws that were not built, like Kate said, for this at all, because we have CCPA, right? We have the the Cal-OPA law, right? We have these things, but instead they're using an entirely different theory and basis. And because they started to use it on session replay a few years ago, I believe that the same plaintiffs bar attorneys were like, well, if we can do it with this high fidelity tracking that's more like a flip book, let's look at basic tracking, which is not like a flip book, but like a one page at a time, because it's the same basic principle. Except, unlike session replay, everybody or most companies engage in some form of tracking technology use, right? So it's much more interesting for the plaintiffs bar. There are a lot more cases. And much like in session replay, we're seeing courts be totally split on this. A lot of them are coming out of California, which is why SIPA is mentioned. But we're seeing federal level cases now. Federica, have you seen any other states? I know there's a number of other copycat states like Florida and Pennsylvania.
Yeah, Pennsylvania has been one, but as you say, courts are kind of split. Sometimes they have, allowed claims to survive motion to dismiss. Other times, no, because maybe there's no personal jurisdiction. But I think we will see more, states, as you say, just leveraging these statutes. And obviously, I just want to add to what Kate said, like these statutes are super attractive for plaintiffs because they have statutory damages. Like in SIPA, they can recover up to 5,000 per claim. Yep, yeah. Without having to prove any actual damages. So they're very attractive. And obviously the arbitration clauses in terms of service raise the price because of the fees associated with triggering arbitration. So, clients are kind of, inundated by demand letters that seek, tens of thousands of dollars before filing an arbitration demand or a claim.
Yes.
Yeah, I think that's a really great. That's a really great practical point, Federica, is that we're also seeing, small dollar attempts at settlement hit, multiple companies. The other thing that I'm seeing from a practical perspective, sort of as in-house counsel, is we're getting these questions thinking about, we're part of the vendor supply chain, right? So we're getting these questions from our customers in their intake when they're assessing us as a vendor. They're saying, hey, are you guys paying attention, and asking us about our use of third-party trackers and chatbots. We're also seeing these in and I would expect that other listeners would see these in their insurance renewals as well, as those sorts of questions. So even though there's a little bit of ambiguity about the traction of these types of claims from a purely legal perspective, we are going to, at least I'm seeing them in my day-to-day practice, having, people want us to have an opinion on them.
So Kate, that's a great segue into item number 3. Obviously, there's a wealth of information with these 3 panelists, obviously, you could see. But in the interest of time, let's move into item 3. And I can certainly get us going here. Spent quite a bit of time kind of doing this with our customers. A couple of things of note. So you need to understand the EU DMA. So the Digital Market Act basically is focused in on 7 companies, or excuse me, 6 companies that are viewed as quote unquote gatekeepers. Those are Amazon, Apple, Alphabet, which we know is Google's mother company. It also is Meta, which obviously owns Facebook, and I'm trying to think what's the Messenger and
ByteDance.
some. Yep. And then we have ByteDance, which is probably the least known out there, and a Microsoft kind of rounds up that list. So the view is these guys are so big that they're stifling competition in a nutshell, right? That the digital economy is not going to be able to flourish in Europe so long as these powerhouses have what they currently put in place.
And just to be clear, Paul, that's the European Commission's view, not necessarily the views
Yeah,
of the folks on the call.
absolutely. From the EU, absolutely. So a couple of things had occurred because this went into effect as of March of this year. So it is in effect. It forced a lot of obviously major players in Europe, companies and so forth, to basically take note and take action. And that action was simply, you no longer could use the existing consent string that Google had offered. So let me break that down. If someone had Google Analytics on your website, you need to understand what is being passed to Google. And what was being done in the past was you would get consent or not get explicit consent, but obviously implied consent. And that notice or that consent string that was originally set up basically was just a single consent string. The notice was sent over to Google. Google took that consent to third-party cookies to mean we now can use your consent and apply it across all of our tool set. And that you can't, that's where the EU stepped in and said, no, you only got consent on that particular tracker. You did not get consent to use it in search, double click, right? All these ad platforms that Google had. So it forced Google to create a new string. So if you've been talking to and you're doing work in Europe, and the marketing team is going, this is chaos. It somewhat is, because all these things had to fundamentally not only technologically change, but obviously philosophically the world had fundamentally changed for the average marketer. So there's a lot of activity going there. The big takeaway here is if you're doing business with Google, something is changing. And it's not just a European thing, by the way. The Europeans are dealing with this DMA issue. In the United States, you're going to see a move away from what was focused on California's consent now to what is called the Global Privacy Platform, or GPP. You're going to see more of a push in the back half of the year on the US side of that. They're going to take Canada, the US, and push that to GPP, and eventually have, including Europe down the road, everyone under GPP and having one consent string for Google. So a lot of activity there. Happy to, if someone wants to get into details, send us a note, and we certainly could share the resources TrustArc has put together around that. The big takeaway is if you're doing business with Google, things have changed. You need to take action. And if you're in Europe, you need to take action now.
Quick drop on Google delays deprecation of cookies. This was and I know we need to move to the next piece because we only have about 25 minutes left, 28 minutes left. But Google has been talking about will they, won't they, like Ross and Rachel from Friends. Will they deprecate third-party cookies? They said they will at the beginning of this year. They deprecated about 1% or 30 million Chrome users, and then they stopped. There was a lot of pushback from industry, regulators, etc. And this can be seen. And I know we have to move on, but just high level there. Many of us in the industry started to talk about, okay, well, what will be the successor? Because it's not simply that third-party cookies will cease to exist. First off, a bunch of other tracking technologies are already heavily in use by companies, trackers, e-tags, pixels, server-side tracking, etc. So, deprecation of cookies is it is a small component, and they are still heavily used, but there's many trackers. The question then became, what will be the successor platform? Because cookies do make up a large portion of the use cases.
Exactly.
And while several proposals came out, i.e. chips from Google, there wasn't enough agreement on what would take over, as well as industry pushback, a lot of concerns from ad tech and ad industry as a whole, etc. So again, like Paul said, we do have to move on, but happy to cover that either in a separate webinar, because we could talk about just cookies for an hour, or if folks have questions, we can see if we can address them. Should we move to APRA?
Yeah, absolutely.
So super high level, just because we are trying to fast track the rest of this page. The APRA was scheduled to be marked up in late June, and for those that aren't familiar, that was the bipartisan federal level U.S. privacy law, the American Privacy Rights Act, which people were very excited about. A friend of mine on social, you can probably find it, did call it a Cheesecake Factory menu of regulations, which I thought was really funny. But it did address quite a bit, which I think was the basis of it. But unfortunately, the House Energy and Commerce Committee basically decided to abandon review or the redlining, or they at least canceled the redlining session. So at the moment, it appears stalled. You'll see doom and gloom messaging on some articles. They're probably clickbait, but we are seeing that there has been some loss of momentum, ranging from opposition from certain states that don't want federal preemption, all the way through to government who views it as overregulation. So lots of sides there, lots of interesting debate for another time. Paul or Federico or Kate, would you like to address the PADFA?
Sure, I can do that. Well, this is actually really pivotal, I think, federal law, because it's kind of the first time that data brokers are subject to national security laws. So what we are talking about is basically a law that President Biden signed on April 24 this year. It took effect already on June 23, so it's in effect. It's basically a law that includes a ban on data brokers from making available personally identifiable sensitive data of US individuals to so-called foreign adversary countries, which is like North Korea, Russia, China, and Iran, other countries, or entities controlled by a foreign adversary. And so the definition of data broker is sort of usual, like, entity that makes available data of US individuals that the entity didn't collect directly from the person. I think what is really important to focus on is kind of how broadly defined is sensitive data of US Americans. Is not just sensitive data as we are, used to under state privacy laws. Is much broader. Is information about a person, online activities, is photos, address book data, financial information is very broad. So I think this is just one piece of the puzzle of a broader focus on data brokers. We've seen this obviously with FTC enforcement actions, with Consumer Financial Protection Bureau proposing to expand FCRA, right, to cover certain data broker activities, and obviously data broker laws that came into effect in California, Vermont, Texas, and Oregon. And by the way, the Texas Attorney General sending letters to data brokers not registered in Texas. So it's like a focus, obviously, is kind of niche to the industry, but I'm sure, many companies, of course, deal with, source data from data brokers, and data brokers themselves make available data to customers. So it's something we are, following closely. But I think the bottom line is really national security laws applicable to data broker. It's kind of a momentum.
But the definition, I mean, it's so wide-ranging, the fact that it's any person who collects data from somebody other than the individual. I mean, that old DoorDash, not old, but the previously mentioned DoorDash case that I just mentioned, a marketing co-op, could trigger that type of obligation. And there's a further definition for sensitive PI, right, around children, I believe, or teens.
Yeah.
Mm-hmm.
Exactly. There is an exception for service provider. Like if you make a data available to a service provider, is not. But obviously, to your point, it's really like, broadly defined.
So in the interest of time, obviously, I'm going to jump to the next slide. A lot of great discussion here. Obviously, section 5 there, it just gives you kind of a really quick kind of landscape view, if you will, of what's been put into place. A couple of things, to call out, I think that are notable in this area is we're seeing a lot of activity. It's not just on privacy specific. We're getting into the AI actions. We're getting into a whole lot of teen different actions. And one of the big things there, just to keep people aware of, and Federica, you certainly could talk more to this, but the big issue is, as we know, COPPA today, right, which is basically under the age of 13, a whole lot of these teen or children initiatives, a lot of it stems from the brouhaha that came out of TikTok debates in Congress. What we're beginning to see is a lot of these actions focusing on under 18 years of age. So if you're under the age of 18, you have to have the parental consent. So just park that, but you're going to see if you're doing stuff in that teen area, you need to pay attention to these child laws that are coming into play, because they're going to likely affect you if you're playing in that market between 15 and 17 years old, type of thing. So with that, I'm going to jump. Just
yeah,
a
Paul,
reminder.
as you're jumping, just because I know we didn't mention it, Washington and Nevada and some others are a direct reaction to Dobbs, the Supreme Court decision. And basically they have additional requirements that are meant to supplement HIPAA around tracking technologies. And a little like we were talking about with the FTC cases, they basically pull in health information that used to be health adjacent and now consider it covered data, which means that your tracking technologies which collect information which may be covered now needs to be also considered.
So let's jump in on here. Federico, you want to talk a little bit about the issues? Well, you certainly mentioned data brokers, but disclosures as well as Kate, in looking at some of these particular items. So if we look at disclosures to start.
Sorry, you mean disclosures for laws, of course. So, well, I mean, the point about state laws is that when these new state privacy laws came up, like Virginia, Connecticut, they largely focus, follow like CCPA. We see like a silver lining, but now there are like some laws, and Texas actually is one example, that have like additional notice requirements. So it really requires privacy specialists and whether attorneys or in-house really pay attention to what these laws requires. And Texas is one example. It requires like a separate, not like a specific notice if you are selling or if you're selling biometric or sensitive information. You mentioned before Washington My Health My Data Act requires like a separate consumer health data privacy policies. There are like some nuances that companies need to be aware of, and so it's really about understanding what types of disclosures you need to provide. Of course, this is a little at odds with the requirement to make sure that notices are clear, accessible, and transparent to consumers. But it's also another consideration is that it's something very easy for regulators and plaintiffs to detect. You just go on the website, you look at the notice, so it's something visible, right, to the public and regulators that companies should really focus on. But I think one key takeaway is really trying to build up your policies in a way that kind of aligns to a standard, a model, and then build on top of that as you learn and as new laws come up.
Yeah, I think the thing that I would add to that is Val sort of jokingly said at the beginning, if you stump us, congratulations. But I think that this part of the reason that we all love this space is because it's changing every day, and it's getting more and more complicated. And we're seeing, to Federico's point, some of these requirements for additional detail conflict with the obligation to sort of be clear and transparent. I've learned things on this call that I didn't know about, and in our prep call that I didn't know. I mean, the reality is that none of us can know all the laws of all the geos. And so sort of thinking about that North Star approach, and then working with, like, I work with my outside counsel. Our outside counsels are going to be the experts in some of these nuances. Federica has clearly demonstrated that she's, knows a lot about these different laws. So use those resources, but to her point, right, think about how you draft in a way that's sort of following that North Star approach, and then you can slide in some of those additional requirements as these laws continue to change.
Kate, a question for you, since you've spent time at sort of mid-sized to small startups and larger, right? How, I know you take a North Star approach, but how do you tackle it? Are you typically trying to kind of one size fits all as often as you can, or slide in those additional addendums? Because I've certainly seen personally companies that have policies that kind of just, they're like, look, we address it generically, it's good enough. And then I've seen others, the biggest, some of the biggest companies in the world, where there is a collapsed menu at the bottom of their privacy notice, and there are 73 addendums.
We don't do 73 addendums. We've definitely taken more of the like, I mean, for me, GDPR is always going to sort of be the North Star. People will argue with that. It depends on your industry, whatever, but I like to architect my program to GDPR and then think about the layers that CCPA and some of these other laws layer in. We include sort of specific language that's targeted at the EU. We include specific language that's targeted at California, and sort of call it what it is after that. We may look at Texas, now that I've learned something new on this call. No, I'm just kidding. But there may be times when we go back and look at other jurisdictions and geographies, but that's how we've taken our approach. And the other thing that we didn't talk about was because it's old now, right? This is how fast things change, is the data privacy framework, and how privacy disclosures are changing in response to the data privacy framework having been passed. That was another sort of, I wouldn't call it seismic shift, but I think all of us in the last 12 months have revisited our privacy disclosures because of that shift.
Yes. Now it's privacy disclosures, DPAs, trust center disclosures, right? It's the list of places where it needs to now be kind of addressed, whether it's for trust building, if you're a data processor for that relationship, or if you're a data controller for the privacy notice relationship. So totally agree there. So I do want to continue talking about the framework. Paul, I'm cognizant of the fact that there's a few others here. What do you recommend?
Well, I think it's important probably to touch on the federal actions, because I think there's a lot of activity going on here that is certainly going to continue to play out. We touched on about the kids in the fervor around that. We've talked about. By the way, that was the first time I saw that acronym, Federica. I've always seen it executive order, whatever it is, 1178 or something. But so are we calling it PADFA now? Is that what it is essentially called? I think to me, one of the biggest things that's maybe flying under people's radar is the Chevron overturning. That is huge, because it could be incredibly disruptive to a whole lot of areas, including privacy. Federica, can you kind of touch on that a little bit?
Sure, I promise I will be short. I'm mindful of time, but I agree with you, Paul. It's super important, right? And obviously, privacy is one aspect of it. So just as a little background, right? The Chevron decision is actually pretty old precedent. I think it was 1984 that established a doctrine, a legal doctrine of deferring to administrative agencies in their interpretation of ambiguous statutes. So when a statute granting agency authority is ambiguous, right, agencies are expected to fill the gap, and a court should defer to the agency interpretation so long as the interpretation is reasonable. It's what it's called a Chevron deference. So what happened is that on a couple of days ago, on June 28th, the Supreme Court overruled Chevron in a case Relentless and Loper Bright. So what the decision says is that judges, not agencies, are charged with resolving ambiguities in statutes. So I don't think we have kind of a clear sort of full understanding of the practical consequences. I think what we can anticipate is that what comes to mind immediately is obviously regulation from federal agencies like Federal Trade Commission. We got the rulemaking on COPPA, GLBA, commercial surveillance and data security, Federal Communications Commission, Consumer Financial Protection Bureau, or on the health data side, the Department of Health and Human Services and the Office for Civil Rights. And so it's kind of, we have to see, right, how this will play out. But certainly it's that I also think it could kind of disrupt Congress' ability to draft statutes that, are ambiguous, maybe, and leave, too much leeway, right, for ambiguities and interpretation, which also, plays out in the context, of course, of all the regulations that I briefly mentioned before.
Chevron is a super interesting case, and I not to humble brag, I recently posted something on Law 360 where they had GCs respond to Chevron, and what I actually said, Federico, was largely similar to you, which was that there are kind of pros and cons because the courts in many situations are the interpreters of ambiguity, and yet for 40 years people have been deferring to the agencies to fill in ambiguities who have expertise that they've built up. But I think by staying neutral, trying to stay like Switzerland, I actually wasn't neutral because most people had a really strong opinion one way or the other, because I think a lot of people have had a very personal, like, legal matter where they've interacted with courts around Chevron. But it's a super fascinating case. I agree that we'll have to see what happens. So yeah, very funnily controversial, but surprisingly so.
And again, in the interest of time, I want to, and I apologize, folks out there, but obviously you can see there's a lot to talk about. On point 5 there, obviously enforcement dates are coming up. So we have a number of those, particularly at the very beginning of 25. So kind of bleeding a little bit into 25, we see a number of things between Delaware, obviously Iowa, Nebraska, New Hampshire, and New Jersey are all coming into effect. A couple of things just to kind of tip the hat to is still a lot of activity out there on the state front. As you can see there, those in that table to the right side there, Louisiana, Massachusetts. About time, Val. Massachusetts gets on the stick here.
Too. Yeah, we're both here.
That's right, Federico. Michigan, I'm in Michigan. It's about time we did something. North Carolina,
Well, and I'm in
Ohio.
North Carolina, so we're all.
Oh, there we go. There we go. We're stepping up. Ohio, Pennsylvania, Rhode Island. They all have active legislation. So it's in some form of their normal process of, making it through the various legislative processes within those states. So if you think that, we've seen kind of the initial push and that it's going to tailor off, I think the answer is it's not tailoring off. It is going to, unfortunately, likely to have 40 plus different state laws dealing with privacy. And as we all have learned, while there is some common tendencies, I have yet to see one that is a pure copycat of the other. There's always some subtle nuances, thus the need for outside counsel or experts to kind of weigh in and kind of provide some practical guidance in those areas.
But
And
you
we
know, I
go
will say
ahead.
to your point about the patchwork, and Val, I suspect that you'll remember this and maybe have an opinion on it, but it reminds me of like 10 years ago when we started seeing all the data breach notification laws come out. You know, I mean, there were 50 different breach notification laws, and many of those sort of remain on the books, and they each have their own flavor to them. So I'm not surprised that we're seeing this sort of cascade of legislation, and I mean, I would anticipate that in the next couple years we see all 50 states, and they all have their own little, you know, flavor to them, their own nuance, to your point, Paul. But you know, again, when we're thinking about breach notification, that's where I would rely on my outside counsel. But it also sort of gets back to that North Star approach.
Yeah.
Fortunately, since then, you know, or fortunately or unfortunately, GDPR was passed. And so I think from a breach notification perspective, we're all with it, living with sort of this 72-hour thing, good, bad, or otherwise. So a lot of that has been superseded, but it sort of, again, gets back to that North Star, like how are you thinking about architecting a compliance program or a privacy program that can live with all of these different nuances?
That's actually a perfect segue to our final segment. So let's actually talk about that a little bit more, and maybe let's just do a quick roundtable for each person on the panel to wrap this up. My personal take on that is that, you know, a year or even a couple years ago, everybody felt like that scene in Dumb and Dumber where they said our pets' heads are literally falling off, for folks who have seen that movie. And I think we're kind of at the acceptance stage of you know, of grief, which is that a lot of us were looking at, you know, all these patchworks, Kate, like you said, right? And the breach notification is a great example, but like we were talking about our prep call yesterday, you know, we look at GDPR as this benchmark, but let's not forget that in 1995, the Data Protection Directive came out, and it took 20 some odd years for us to go from that to GDPR, which helped to unify to the extent that we really wanted it. And so I think that, you know, I think embrace the chaos a little bit is one recommendation I have for folks. And two, there are way better tools out there now than there were 5 or 10 or 20 years ago. You know, like, I don't know if folks have gone to that DLA Piper website that has all the breach notification laws around the world, but that didn't exist like 20 years ago, I don't think, right? Or 10 years ago even. Like, I don't know when it came out, but the point is that people didn't have those things. People didn't have Nimity AI or CoCounsel or all these other tools where you could quickly search something before. And so I think embrace the chaos is my one recommendation, and adopt the North Star approach that Kate was talking about. My quick list there of ones to consider: GDPR is great. OECD privacy principles, oldie but a goodie. They came out in 1980, I believe. Nimity has a privacy management framework that is free online from TrustArc that you can check out. APEC has their privacy framework as well. And then there's also the ISO standards, the SOC 2 standards, but those are all great North Star type frameworks. And what you'll see is repetition throughout, right? You'll realize that they all talk about minimization. They all talk about data retention. They all talk about transparency. It's because these things aren't as new as they may seem if you pull up the proposal for Massachusetts or wherever.
Val, the one I would add to that is NIST.
Yes, this is a great one.
Kate, what are your thoughts here?
Yeah, absolutely. So my biggest sort of takeaway and sort of how I fell into this privacy thing that we're all doing now is just know your tech, right? Like, I always had an aptitude for kind of asking questions about, well, how does that work? Explain that to me. And somebody, you know, this whole privacy was really becoming a thing, and somebody, you know, to use an analogy Val has used before, sort of dubbed me like the person because I asked the questions. But I would say, like, really know your technology is really, really important. because when you're making that, when you're thinking about that North Star approach, you're going to have to make some risk determinations and you're going to have to make some trade-offs. And if you really understand your technology, whether that's vendor technology, whether that's your products, whether that's, you know, what your company does, et cetera, or what's out there, right? Like, I mean, not to belabor a point that we're all sick of hearing, but like AI is so big right now, but do you really understand it? And if you really understand it, some of those risk trade-offs sort of become a little bit easier because you can think about how the technology works. So I think that that's my biggest takeaway, is just really get to know the technology. And these are not going away, right? AI is going to be changing extremely fast. I went to a CLE personally recently about the metaverse and I started thinking about all the privacy issues there. So just stay up to date on the technological changes.
Federica?
Agree with everything. I'm just gonna have 2 cents on AI because I cannot do anything else than doing it. It's so, you know, everywhere. And we didn't mention before, but we got the first, you know, big, you know, AI Act, right, in Colorado, which will apply from February 1st, 2026. So it's not immediate, but still, really a focus should be on, you know, if you're using, I don't know, like a customer AI, you know, interaction tool, a chat, or you know, generative AI, whatever, think about that. And obviously beyond privacy as well, right? It's just an sort of think about how you want to address AI risk in your business, right? Build like a governance plan, understand what data your third-party vendors are using, if at all, to improve their services, or put restrictions if you can, or understand, to Kate's point, in terms of the technical side, what the AI tool is doing and what you want, you know, the vision be for your company from an ethical perspective too. And I'm sure, aside from state comprehensive privacy laws, we are going to see more and more states enacting AI bills and laws similar to the Colorado initiative, and Utah as well as an add-on to its consumer protection law.
Thank each one of you for a fantastic webinar.